This is an AZCourtHelp Legal Talk on How Do I Disagree with a Family Court Order, presented by Stephen D. Wolfson of Dickinson Wright, PLLC. Thank you.
My name is Steve Wolfson. I'm an attorney with Dickinson Wright here in Phoenix, and I've been a family law attorney here at our office for going on 31 years now. Also a certified family law specialist, which just means that I meet and have met since, I think, the early 2000s, certain high standards that the State Bar of Arizona has for family law attorneys. I also serve as a judge pro tem in the Maricopa County Family Court. In that capacity, sometimes I will be a substitute judge, if you will, when a judge is unavailable. But more often than not, on average once a month, I will serve as a judge pro tem for alternate dispute resolution, ADR settlement conferences. And that's where I try to help parents or parties who don't have children to reach agreements so they can navigate their way through the process as easily as possible. I've also worked with the Arizona Supreme Court on different projects to revise and reform the family court rules and procedures statewide of changing court orders. So when a court issues an order, usually it'll fall into one of two categories, and that's how I'm going to try to present the explanation of the applicable rules or the applicable statutes. Because in Arizona family law, we have a set of statutes. Those can be looked up, as my kids say, just Google it, under the Arizona Revised Statutes, ARS, and then I will give you certain numbers of those statutes to take a look at to see the specific language. And then in addition to those statutes, we have certain family law rules of procedure that, again, can be Googled under the and are actually posted on the Arizona Supreme Court's website as the Arizona Rules of Family Law Procedure. So I'll refer to both the statutes and the rules. We have orders that the court issues before a final decree of dissolution or legal separation is entered. And then we also have orders that may be entered after a decree. So when I talk about pre-decree or post-decree, that's what I'm referring to. And so even within those different time periods, we have different rules or statutes that may apply to different issues. So as a general recommendation, if you feel you need to ask the court to change or take another look at an order that's been issued, it's real important, especially if you're representing yourself, to identify for the court the particular rule or statute that's applicable. Because if you do that, your request is likely to be a lot more persuasive with the judge. So let's begin with pre-decree. During a case, a court may issue an order for child support or spousal maintenance, and that may be a temporary order. So there are sometimes the need to ask the court to change those orders because there's been a change of circumstances. Maybe your income has decreased, or maybe your spouse's income has increased, or vice versa. And so the first statute that's applicable is ARS 25-327. So ARS 25-327 basically says that whenever there's been a change of circumstances with regards to, and this mostly applies to child support or spousal maintenance, but it could apply to other issues. But focusing on child support and spousal maintenance, if there's been a substantial and continuing change of circumstances. So I just talked a few minutes ago about your income changing or your spouse's income changing. That's just one example, but it needs to be a substantial change, and it needs to be a continuing change. So what do I mean by continuing? I mean that it's a change that goes beyond just one pay period or probably 1 month. So if you were ill, or your spouse was ill, or their income varies from month to month, if there's just one offhand period of time where the income increased or decreased, that's probably not a continuing change of circumstances. So if there is a substantial change, and if it is a continuing change, meaning that it's going to continue to occur for a period of time, you would want to identify 25-327 to the court, 25-327. So that would apply to a request to change spousal maintenance or child support. Now, at the same time, there are rules that apply, and I'm not trying to make this more complicated than what it already is, but sometimes you'll want to cite or list and identify for the court not only a statute, but a rule. And so in this case, the example that I was giving, where there was a change in income, and that change in income could affect the amount of child support that one parent is paying to the other, you'd not only want to cite 25-327, but you'd want to cite Rule 83, because Rule 83 affects orders that have already been issued by the court and is one tool that you have to ask the court to go back and review its decision to make a different decision. So again, as I said in the beginning, there are both statutes and rules, and all of these statutes and rules, because I did it this morning, can be Googled. So if you Google or look up Arizona Rule of Family Law Procedure 83, you should see the link to the state of Arizona Supreme Court's website, and you can see the specific language of that particular rule. So we've talked about very briefly requests to change child support or spousal maintenance, but also in the Arizona statutes, the Arizona revised statutes, there is a specific statute regarding a request to change parenting time or legal decision making. And that is 25-411, 25-411. So if there's a situation that requires, in your mind, a change of legal decision making or parenting time, you would want to identify 25-411 to the court as the basis for your request. Now, 25-411 is a little bit more complicated. Not only can it involve a substantial and continuing change of circumstances, and that's kind of a theme with requests to change orders, because that applies to both spousal maintenance, child support, and also changes to legal decision making or parenting time. But in addition to showing the court that there's been a substantial or continuing change of circumstances, you can also say to the court, again, based on 25-411, that a change is in the best interests of your minor child, children, son, or daughter. So that's an additional reason under 25-411 to ask the court to change the current order regarding legal decision making, or parenting time. So I hope that that makes sense. Now, getting back to those rules, it's important to look at the specific language of the rules and try to see which part of the rule applies to your particular situation. So, for example, under Rule 83, it says that a court can go back and review and decide whether it's appropriate to change an existing order based on very specific reasons. And I'll mention a few of those reasons right now. That number one, or A, the court did not properly consider or weigh all the evidence. So if you went to a hearing and you presented evidence and the other side presented evidence and the court issued a ruling, it's possible that the judge, he or she, did not really understand all of the evidence that you presented or understood how it affected the issue, whether it was child support, spousal maintenance, or legal decision making, or parenting time. So if you believe that the court missed evidence, didn't understand it, didn't really consider it, maybe it's not mentioned at all, you could use that part of the rule to ask the court to change the order. There's some other parts of the rule that may not be applicable. If there's an irregularity in the proceeding or an abuse of discretion by the court depriving the party of a fair trial, that also could be another reason. Let's say you went to court and the court said had said previously that you'd be entitled to an hour, or both spouses would be entitled to an hour, and you got to court and the court said, no, we're only going to spend 30 minutes. And you didn't have enough time to present all your evidence. That might be an example where that part of the rule could be appropriate to ask the court to review the order, change the order, modify the order, and possibly take additional evidence to allow a better, more informed order to be issued based on the issue. The third reason, and again, these are independent of each other. You do not have to show all of these reasons, and that's why it's important to look at the language under Rule 83 to decide what part of the order is applicable to your situation. The third part is misconduct of the other party. So that might be an example where you would say, well, the court issued this order, but the other side didn't give me information. And had he or she given me information that I needed, the court would have better understood the issue and would have issued a more appropriate and accurate order. The fourth reason is accident or surprise that could not reasonably have been prevented. Maybe something changed right before the hearing or trial, and you didn't get an opportunity to present that information to the court. That might be an example of an accident or surprise that couldn't have been avoided. The next is similar, newly discovered evidence that could not have been discovered or produced at trial with reasonable diligence. That means, again, information that maybe just came to light either just before the hearing or trial or after the hearing or trial took place, that again impacts the order of the court and should be something that the court considers. The next reason would be an error by the court in the admission or rejection of evidence. So again, it's hard to give a specific example, but if you had a witness that the court didn't allow to testify, you could argue that this witness is very important for the court to hear from, and that the court made an error not to hear from the witness on the particular issue. The final two reasons are more general, and they typically have to do with law, either a new case or a rule or a statute that the court didn't consider. So that would be that the court mistakenly overlooked or misapplied facts or made mathematical errors that affected the ruling, or finally, that the decision, findings of fact, or judgment is not supported by the evidence or contrary to law. So that would be a catch-all where you would be arguing to the court under Rule 83 that the court failed to consider certain facts that had been presented or failed to follow certain law, again, whether it's a statute, a rule, or a case that's been issued by the Arizona Court of Appeals or Arizona Supreme Court, and that those errors affected the order of the court, and that those errors should be reviewed and part of a new modified order. So Rule 83 is a real treasure trove of reasons to ask the court, either pre-decree or post-decree, to change, modify, amend, and to review whatever order that it's issued, whether it's, again, child support, spousal maintenance, legal decision-making, parenting time, and sometimes even property-related issues. So there's a couple other rules that also may be applicable, again, depending on the situation. And these, again, are all under the Arizona Rules of Family Law Procedure. So again, if you look it up on the Arizona Supreme Court website, you will find a link to the Arizona Rules of Family Law Procedure, which are applicable in every county because they're statewide rules. So Rule 84, I just talked about Rule 83. Now Rule 84 is a little bit different. It's mostly used when you're dealing with a mathematical error. You're not dealing with witnesses. You're not dealing with some sort of legal argument. You're dealing with something that really just needs to be clarified. And that's what it's called. Rule 84 is a motion for clarification. So that might be the judge issued an order and he added instead of subtracting, or he subtracted instead of adding, or the way that the judge described the order could be interpreted a couple different ways or doesn't make sense. The use of Rule 84 is much more limited than any of the other statutes that I just described or the rules. It's a very narrow request to the court to say, you know, I think you just kind of made a mistake on a very specific issue, and I'm asking you to clarify and possibly correct what, as I said before, may be just a mathematical error. And judges do that from time to time, as do all of us. Maybe he or she was going very quickly, and they put in one column an amount that should have been in the other column, or vice versa. You could use Rule 84 to bring that to the attention of the court. Now, finally, Rule 85. So we talked about Rule 83. We talked about Rule 84. And finally, Rule 85 also has a laundry list of reasons that may be applicable to ask the court to change an order. Rule 85 is a little bit different than Rule 83, not only in the reasons that are listed, but in the time period where it can be used. So again, not trying to make this more difficult than what it already is, but a Rule 83 request has to be made to the court within 25 days of the order. Okay, so again, to repeat that, You get a copy of an order from the court. If you believe that it's wrong, not just because you don't like it, but because there's a reason that it's wrong, a specific reason that it's wrong, you have 25 days to ask the court to amend, modify, or change that order using one of the reasons that is listed in Rule 83. Rule 85 has a longer period of time involved, but different reasons. So there, reason number one might be a clerical mistake in the way that something was written. Number two, that again, there was newly discovered evidence that was not available at the time of trial that affects the order issued by the court. Number three is fraud. If one of the parties misled the court materially with regards to information such that it rises to the level of a fraud, that is another reason. And then the other reasons get a little bit technical. Next, that the judgment is void. After that the judgment has already been satisfied or released or has been discharged. And then finally, there is a catch-all under Rule 85, which is any other reason justifying relief. Now, it sounds very broad and very open-ended, but it's really not. That really applies to situations where the judge issued an order, it got sent out, but you never received it. So of no fault of your own, and let's say it said you're supposed to pay your spouse $100 within 30 days. Obviously, not much of an order, but if you never saw it, you wouldn't have the ability to comply with it. So one of the reasons that would qualify under that particular part of the rule would be that the court maybe sent it to the wrong address. As many counties do these days, they will send out copies of orders or minute entries to an email address that the court used an incorrect email address, and you later found out about it somehow. That would be the type of reason that you had to identify for the court, even if it's beyond the 25 days that I just described for Rule 83. You would say, well, I understand it's 2-3 months later, but I never received it. I wasn't mailed to the correct address. It wasn't emailed to the correct address. And so you should either give me more time or you should change the ruling for other reasons. So Rule 85 is similar in certain respects to Rule 83. There are additional reasons to use under Rule 85 and a longer time period involved. And that generally applies up to 6 months. If you're beyond 6 months, it's going to be difficult to convince the court to make any changes of a particular order going back to that original order. Again, if there are changes in circumstances, whether it's child support, spousal maintenance, legal decision making, or parenting time, those can be presented to the court when they come up if they are new circumstances, substantial circumstances, continuing circumstances. But that's a little different than what I was just talking about with regard to Rule 85. That's saying, oh, I have this order and I want to change the original order. I'm not asking the court to issue a new order based on new things that have occurred. I'm going back to this original order and I want the judge to go back to it. That's more difficult, and you need very specific reasons to do that, especially when more time has passed. So finally, we've talked a little bit about changing orders during a case. We've talked a little bit about changing orders after the end of a case. That would be post decree. Finally, the most extreme form of asking for a change of an order is through an appeal. Very difficult to navigate on your own without the help of counsel, but that would be an appeal from your trial judge to the Arizona Court of Appeals. So the Arizona Court of Appeals has the ability, under certain circumstances, limited circumstances, to review the decisions made by your trial court judge. The appeal from the trial court to the Arizona Court of Appeals is a very involved process. It's a very lengthy process. In some cases could take from 12 to 18 months from beginning to end, and can be an expensive process if you're using an attorney. So the Arizona Court of Appeals generally focuses on issues of law. If there's a legal issue, they will review that issue brand new. That's called de novo. If it's a factual issue, it's something that it's difficult to get the Court of Appeals to review some application of facts to the case, because they give trial court judges significant, wide, broad discretion to resolve those issues at the trial court level. So the Arizona Court of Appeals is not likely to review or change factual issues, how facts were applied to the case, unless it finds that the judge, he or she, abused their discretion, that they completely rejected evidence, that they ignored evidence. And, you know, by and large, over my 31 years, I don't find that occurs on a regular basis. But again, the appeal would be the last opportunity to ask for a change in a particular order or judgment and decision of the court. So again, you know, so far I've described certain rules from the Arizona Rules of Family Law Procedure. I've described certain statutes that are applicable from the Arizona Revised Statutes. This is all under Title 25. Title 25 is where you'll find virtually every family court statute, and the ones that are applicable usually, typically, to request to change orders would be 25-327 or 25-411, having to do with legal decision making and parenting time. So in general, those are the options that you have for asking the court to change orders that have been issued. And again, every situation is different. Every issue involves applying different rules or different statutes. It's important to look at the specific language. And when the Arizona Supreme Court a few years ago revised and restyled the Arizona Rules of Family Law Procedure, there was a real emphasis on trying to make those rules easier to understand, more usable, more user-friendly. And so hopefully when you review some of those rules, it will become easier to see how they might apply to your situation or how they might not apply to your situation. Because as I said before, you know, we kind of took apart the rules, we added language, we separated out other language, so that when someone's looking at a rule, it can be followed a lot more easily than it might have in the earlier version. And because, you know, the rules are to help parties, parents, not just attorneys. They're there for everyone within the family law system to have the benefit from. And so hopefully when you do review them, they'll make some sense. And again, there are some issues that you may need to consult with an attorney on because you're not sure about how the rule or statute applies to your particular situation. And that's where, having some legal advice, may help. But if nothing else, you will have the background with the rule or with the statute to understand, the basis and the background of what the court needs to look at when it's faced with a request to change an order. So hopefully that was helpful. Take care, everyone.
Bye-bye.